Before your first evidentiary hearing in divorce court. If you are about to attend your first evidentiary hearing or trial in a Utah divorce or child custody case, you need to understand something immediately. Court is not designed to operate like ordinary human conflict. Most people walk into court believing that if they simply tell the whole story, the judge will understand everything and do what feels fair. That is not how evidentiary hearings work. An evidentiary hearing is not therapy. It is not a moral referendum. It is not a chance for you to unload years of frustration. It is a structured legal process designed to answer specific disputed questions using admissible evidence. And many litigants do not realize how specialized that process actually is. One of the biggest mistakes people make is confusing argument with evidence. Saying, he's manipulative, she alienates the children, or he's a narcissist is not evidence by itself. Courts need proof. They need testimony, exhibits, financial records, authenticated communications, photographs, recordings, and legally relevant facts. Relevance matters enormously. Many facts that feel emotionally important may not matter legally at all. Judges are not trying to determine who is the better person. They are trying to apply statutes and case law to admissible evidence. Another thing that surprises people is how formal and unnatural courtroom procedure feels. You generally cannot just hand the judge screenshots and expect the court to sort everything out. You may need to authenticate exhibits. You may run into hearsay problems. And hearsay is one of the most misunderstood concepts in family law. People constantly say things like, "My child told me," or "the therapist said," assuming that should automatically prove something. But courts prefer evidence that can actually be tested through questioning and cross-examination. The same thing applies to digital evidence. Modern family law cases are flooded with screenshots, text chains, recordings, and social media posts, much of it incomplete, disorganized, or stripped of context. Judges are not eager to reconstruct your marriage from 600 screenshots and 30 mislabeled PDFs. And yes, that happens constantly. Presentation matters too. Long speeches, interruptions, emotional outbursts, and repetitive testimony usually hurt more than they help. The litigants who perform best are often the ones who remain organized, focused, responsive, and credible. That does not mean emotion is irrelevant. Family law cases are emotional. Judges know that. But emotional intensity is not a substitute for evidentiary strength. If you understand that the purpose of the hearing is to present legally relevant evidence clearly and credibly, not simply to express your feelings, you will already be ahead of many litigants walking into family court for the first time.